Assalamu alaikum wa rahmatullah. We'll be starting our class on Multaqa al-Abhur momentarily, بإذن الله تعالى. نسأل الله سبحانه وتعالى التيسير والتوفيق والثبات في المسير. بسم الله الرحمن الرحيم. الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا وحبيبنا وقرة عيننا محمد وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. Alhamdulillah, in our lessons on Imam Ibrahim al-Halabi's Multaqa al-Abhur, we're continuing to look at the section on impermissible transactions. And we're going to begin today by looking at this issue of what cannot be sold. It includes قال رحمه الله تعالى ولا شراء ما باع بأقل مما باع قبل نقد الثمن. So you cannot sell what you cannot buy back what you yourself sold for less than the amount you sold it for before the price is paid. وكذا شراؤه, likewise buying it from another with the first price before one has made the first price. ويصح في الغير بحصته. Okay, so the underlying issue here is that it is possible, there are ways that one can incorporate the meaning of riba into one's transactions. And that is not Islamically desirable. So what do you do? And of course, you should not do this. But let's say Zubair sells, so ولا شراء ما باع. Let's look at the example. Right? Nor can you buy back what you sold for less than you sold it for before you paid the price. So let's say that Uncle Jamil wants to lend $100,000 to Zubair. Can he charge for lending him money Islamically? No. But what he does, he sells him $100,000 worth of media equipment. And then he buys it back, and before any payment is made, he buys it back for less than what he sold it for 80,000. So what happens as a result? So Uncle Jamil sold the media equipment to Zubair for 100,000. He bought it back for 80,000 without there being any exchange of money. So what happens? Suddenly, Zubair, who's trying to get married to his daughter, Zubaydah, owes Uncle Jamil $20,000. So he gives him a $100,000 loan. So he says, okay, look, I'm giving you this qard hasan, payable as 100,000, but you also owe me 20,000 for this transaction that just took place. So this is a hilatul riba. This is a trick for riba. And as the commentator says, that shubhatul riba في يعني كحقيقة الربا. Right? That which resembles riba is like riba. That which resembles riba is like riba. So this would be a problematic contract. Now, if you do this even before the payment is made, it corrupts the contract itself. If it's done after the payment, it becomes makruh tahriman, right? Because you didn't even make the payment, but you did this, then that would render the transaction itself to be corrupt. But these kinds of hilas of riba are Islamically problematic. Right? They are Islamically problematic. And one of the issues that one has to be aware of is where there is a legal resemblance to riba, like in the example we gave. Right? And to understand these examples, and you're students of knowledge, don't just read the text again and again and try to understand it. What you should do is come up with a simple example. Instead of, if someone sold something and bought it back, give a tangible example like the example we gave. 100,000, Uncle Jamil sold $100,000 of media equipment to Zubair. Before the payment is made, he bought it back for 80,000. So what's the problem now? If you write it down, say, oh, as Ibrahim mentions, suddenly you have a $20,000 debt that has arisen. And this would often be connected, as you can imagine, with having a loan connected with it, whatever, or a financing agreement. So this creates a hilat al-riba. And hilat al-riba is problematic for obvious reasons. Because there's a divine wisdom in prohibiting riba. Right? It's not just ta'abbud. It's not just a devotional matter. And we'll be coming to the chapters of riba. And we have many resources on Seekers regarding them. Okay. And then from what can't be sold, he says, is وَلَا شِرَاءُ زَيْتٍ عَلَىٰ أَنْ يَزِنَهُ بِظَرْفِهِ وَيَطْرَحَ عَنْهُ لِكُلِّ ظَرْفٍ مِقْدَارٌ أن يطرح عند كل ظرف مقدار معين. Right? So one cannot sell oil on condition that it be weighed in a particular container. Right? So, okay, I'm going to buy this oil, 10 of these tanks of that oil, but with every tank, we'll exclude 1 liter. What's the problem? If the tank is not known, right, then this, and this exclusion, this can lead to non-definition and dispute, right? This could lead to non-definition and dispute. وإن شرط طرح مثل وزن الظرف يصح. But if one makes the condition that we will remove a specified extent of the actual container, this would be valid, because then this non-definition and the possibility of dispute would be thereby lifted. وإن اختلفا في الظرف وقدره فالقول للمشتري. And then, if they differ regarding this container and how much it actually contains, the seller's opinion will be taken, because he's denying that there's enough, right? And the word of the one denying is taken. And this would happen because very often people would play tricks on containers, right? You have a container that's this big, but they put in that, they raise the bottom up, because you save 10% or 5% and so on. So this is why there's so many incentives in cheating in trade that the Prophet ﷺ warned, at-tujar humul fujar. Right? Traders are the most corrupt, right? Because the corruption that arises in trading, and in the marketplace, it harms not just the trader spiritually, but harms their spouse, their children, their family, the people they provide for. It brings darkness around them. It affects those who buy and sell from them because barakah is taken out from those transactions. So it's a serious matter. So this is why, and if they differ, the word of the buyer, the mushtari, is taken because he's denying that extra. Okay. ولو أمر مسلم ذميا ببيع خمر أو شرائها صح خلافا لهما. So if a Muslim orders a non-Muslim, a dhimmi, to buy wine or sell it, this is valid as opposed to the sahibain. وكذا لو أمر المحرم غيره ببيع صيده. Likewise, if the one in ihram, the muhrim, orders another to sell their hunted animal. But here, it is important to note, as the commentators mention. So what's this? What's the scenario? Right. The scenario, the issue is that this is according to Abu Hanifa. Right? If a Muslim orders a non-Muslim to sell something that is haram, like wine, like pork, like other haram things, this is valid. Why is it valid? Sadati. Why would it be valid? Okay. But who is engaging in the sale? Yeah. So in this case, the transaction, the agent is the one who's entering into the transaction. So the agent enters into the transaction. Is it valid for a non-Muslim to sell these things, provide these services? In worldly terms, yes, it is. We acknowledge their right to do so. So this is valid. Now, when they say sahha, what are they not addressing here when he says sahha, that it is valid? What is it not addressing? What is it not explicitly mentioning? Yeah, he's talking just about validity. And as the commentators make clear, this is makruh tahriman. And ويكره أشد الكراهة. This is very intensely very intensely disliked. But the transaction itself is valid. Right? The Sahibain did not accept the validity of this. But there are situations where this would be of consideration. I witnessed a number of times with Shaykh Adib Kallas, rahimahullah ta'ala, who's a God-fearing alim, may Allah have mercy on him, that let's say if someone inherited their, or someone had to manage their parents' chain of pizza stores, and the whole family is in significant debt, etc., very complicated circumstances. So there's a situation of ikhtiyar, right, where you have a choice. But let's say the whole family is on the verge of bankruptcy, they're over leveraged, etc. Now, the son is in a situation where father had a massive heart attack, he died, he has to run this. Now, he wants to get out of the haram situation, but how do you navigate this? Can you just do the outright haram? So, there, very carefully, with careful consultation, right, that you could have a non Muslim manager handle these things. Like, if, let's say if they're just selling, you know, let's say there's a pizza store and they sell only pepperoni products and they're a franchise, they don't have permission to switch to halal pepperoni, whatever. So, so they require steps, right? They've gone through all the means of getting out of the haram situation. But is it a simple alternative to just say, okay, we'll just shut down our franchise and thereby declare bankruptcy, and there's 4 siblings in university, and the parents will lose their home and their investments, everything, and the mother then would be in a difficult situation, right? So these are complicated life situations. So in complex situations, this is akhaful adrar. One cannot just do it willingly. That, okay, you want to sell haram things, just hire non-Muslims to do it, because it's karahat tahrim, it is sinful, right? That milk, the earnings from that would be khabith, but they would still be valid earnings, but khabith. So one can do things like this transitionally, but under careful, skilled consultation to get out of that situation. And the recommendation and the command would be that any profits from such, this can only be done transitionally, and any profits from this kind of transaction, what would one do with them? One would give them in charity, takhallusan min al-haram, right? Because the makruh tahriman, when it comes to halal and haram, is akin to the haram, right? So these are sensitive situations, but this is why one requires a faqihun mahir, right? Sometimes one treats with poison, but if you give too much, you kill the patient. You don't use enough, it does not work. As Shaykh Adib put it in a different scenario, rahmatullahi ta'ala alayhi, right? But this is in itself, so this, we have to be very clear. This issue, it is valid, but it is, as it's related from Imam Abu Hanifa, right? As mentioned in in Majma' al-Anhur, وقد روي عن الإمام أنه يكره أشد ما يكون من الكراهة. Right? It is as intensely disliked, i.e., it's prohibitively disliked, as close to being haram as possible. And so it would not only be allowed in situations of genuine need that is akin to necessity, right? Where not doing so would entail massive harms. Okay. And that's why from the awsaf of the mufti is that they have to have taqwa of Allah subhanahu wa ta'ala. Okay. It also highlights why the fuqaha say that you cannot, the books are silent without their keys, which is the requisite training. Without the requisite training, because otherwise, as it's come from the early Muslims, al-isnadu min ad-din wa lawla al-isnad laqala man sha'a ma sha'a. Okay. And then ولو شرك كافر عبدا مسلما أو مصحفا صح ويجبر على إخراجهما من ملكه. Now, with respect to the mushaf, this would, that can a non-Muslim buy a mushaf? The basis is that Muslims should need to be careful about how people deal, with our book, the Quran, right? So this idea of just distributing it freely without consideration is not desirable, right? If given out, it needs to be given out in a manner that people would respect it. If it's given out in a way that is of consideration, then it can be given out. And so, for example, if people are distributing Qurans to non-Muslims, one of the things the Mashayikh would recommend, for example, is to include a book about Islamic beliefs or introduction to Islam, or a book about the Prophet sallallahu alaihi wasallam, or a book about the Quran, and to have something indicating the person is interested, and to have some etiquette with it. Right? Okay. So this was the completion of the previous lesson, and we saw these things, distinguishing between the corrupt and invalid sale, the causes of corruption, the rulings of a corrupt sale, and some of the associated matters. We're going to continue bi'idhnillahi ta'ala into lesson 8, which looks at the rulings of corrupt sales. Right? وَالْبَيْعُ بِالشَّرْط. Right? The selling with a condition. So we ask Allah subhanahu wa ta'ala for steadfastness and ease, and we'll continue from here. Bi'idhnillahi ta'ala. But any questions before we proceed?
I have a question.
Go ahead.
Does buying haram food or buying like I don't know like haram animal food like pet food does that count as bay fasid or bay batil?
Okay, so that's a tricky question for several reasons. Amongst them, the issue that what is the ruling of buying such pet food to begin with, right? Um, right. So what's the problem with pet food?
Usually haram.
No, but why? What would the issue be with pet food?
Be considered meta or not slaughtered.
Yeah. So pet food from unslaughtered. So the selling of unslaughtered animals is impermissible, right? Is meta considered mal mutaqawwim?
No.
No. Right? So meta, unslaughtered meat is not considered a matter of recognized value. So if it's not a matter of recognized value, so in itself, right, that can a Muslim buy uh, pork chops to distribute to their neighbors, for example? They're not going to eat it themselves. Hmm?
No.
No, right? Why? Because it is mal غير متقوم. Right? It is يعني, of non-recognized value. Right? Which is that the Sharia has not made it permissible to use. So you cannot acquire that. You cannot acquire that. So, that's a general ruling. Now, when it comes to pet food, for example, this becomes an issue. If you were, if you want to be a person of taqwa, So let's say Sidi Abdul Latif wants to keep some cats. He would feed the cats what's best for them, which would be properly slaughtered meat. But that's not so straightforward, right? That's not so straightforward. And there's umum al-balwa in the situation, in this matter. It's not a simple issue. I asked some of the leading fuqaha and they had tawaqquf on the matter. But there are others, and I believe we have answers in the Seekers Guidance Answer Service, that basically you could, that there are different furu' in the Hanafi school that if this najis matter has a recognized use, and prohibiting it'd be considered from umum al-balwa. It's widespread harm. So, for example, people keep pets. There's a general encouragement in the Shara to keep pets. And they generally feed them this. So the key supporting furur would be related to the purchase of excrement for the purpose of fertilizer, which the ulama permitted. Initially, they said, well, it's best if the fertilizer be mixed with soil, but farmers were like, we already have soil. We just need the manure. So they said the same thing, right? That, okay, this is a matter that the manure on its own is not of recognized value, but in itself. But if it has recognized value, right, is fertilizing soil something the Sharia accepts? Yes. So in that, and is there a widespread, or is there a darar am? Yes. So that's what the Prophet ﷺ said, تُحْدِثُونَ وَيُحْدَثُ لَكُمْ. You inaugurate things and rulings are inaugurated for you. So there is that argument. And many fuqaha have given fatwa on this. So that in particularly in the absence of alternatives, if you have a pet, you can go get pet food for them. If you did that, which is more precautionary, that would be better. You'd be rewarded for it. But it's not so straightforward. So that's what they say. I don't really feel comfortable with that, even though we have 3 cats. And okay. بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا محمد وعلى آله وصحبه وسلم. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. We're moving on to lesson number 8, in which we are looking at the rulings of corrupt sales. باب البيع الفاسد والبيع بشرط, right? يقتضيه العقد. And here we'll be looking at the different types of conditions and their consequences to begin with. And there's a number of important points that we will be looking at. Firstly, to understand when a condition corrupts a sale and when the condition is valid. Number 2, to differentiate between consequences of both valid and corrupt, of both invalid and corrupt sales and the issues of resulting liability. We'll also look at the cases where sales are disliked, like selling after the adhan on Friday, for example. And there are certain key concepts that we will be touching upon, bi'idhnillahi ta'ala, amongst them, that what are the conditions that are not entailed in a sale? This is important. The basis of transactions is that they be clear, defined, and simple. Adding too much complexity to a transaction raises the possibility of dispute, raises the possibility of injustice, and that's why it has come, Naha Rasulullah sallallahu alaihi wasallam an bay'ataini fi bay'a, right? The Prophet forbade two transactions in one. Um, and we look at some of that. And how do we differentiate between the price, which the thaman, which is what the two parties agreed upon, and the market value of the item, the qima. And we'll be looking at al-bay' al-makruh, disliked sales as well, bi'idhnillahi ta'ala. So let's look at this section. Conditions and corrupt sales. And we can summarize it as follows regarding conditions in sales. So you have conditions that are entailed by the contract, and these are valid. What are conditions that are entailed in a contract? You just define the terms of the agreement. So, for example, if you sold this power bank, right? You sold this power bank. So you define that this power bank is, 10,000 whatever units they are. It has a kickstand. It has a USB-C port. It also connects wirelessly, etc., etc. It weighs less than this amount. You define the color. So you define the terms of the agreement. So these are entailed by the contract. We agree that you will pay in installments. So let's say it's $50. You'll pay $10 a month for 5 months. So the conditions. So if we agreed to that, if you bought a black power bank and I delivered you a shocking pink one, is that condition of consequence? Yeah, you have a right to, demand the right item, or if I say, sorry, that's the only one I have, to cancel. And defining these kinds of terms clearly is important so that you get what you understood. Because very often we have to distinguish as mutafaqqihin between negotiation and the sale. Because this is where very often there's possibility for either cheating and deception on the one hand, or mistakes that we negotiated for a while over this book stand. And it has particular characteristics, whatever. But then when we went to deliver, the actual agreement was the things that were negotiated, they didn't necessarily carry over into the sale transaction. And this is often a problem in small sales like this book stand, but also in big things. You purchased a house, and remember we discussed the things, what enters without mention and what needs to be mentioned, etc. And the negotiations are sometimes in writing, but often how do negotiations take place? Yeah, very often they take place verbally. And people have their selective memories of what the negotiation was. So it leads to dispute. So it's good practice that what you agreed in the negotiation, to document it, and then to carry over the relevant negotiated items into the actual contract, particularly related to what is being purchased, what enters, what doesn't enter. Okay, so this is not superfluous. Some people say, well, if it's entailed by the contract, why mention it? Right? But there's other components as well. This would also include, for example, when the payment is due. Is it in installments? Um, how will the item be delivered? So if you buy a sofa, do you have to pick it up from the store, or will they deliver it? Now, if Uncle Latif, during his lunch break, goes and buys a sofa, will he want to take it with him right away if it's during his lunch break? Uncle Latif, lunch break, you're going back to work. You're going to take you are you going to want to take the sofa right then? Yeah, quite possibly not. But if you're the guy selling the sofa, do you want to hang on to someone else's sofa now? No, right? Because one, if you're a successful business, you want to turn over your inventory as quickly as you can. We sold this sofa, clear it, bring something in else from the warehouse or from the back to put it on display, sell it. And that's how you make money. So conditions that are entailed by the contract are valid to stipulate, and all relevant terms should be stipulated. And it's a sunnah to stipulate um, terms in contracts in writing. Okay. Then there's conditions that are not entailed by the contract. These are problematic. There's one type of condition that there's no material benefit to either party. And these are valid and of no consideration. Such as what? Let's say that Sidi Masir gave me a nice white scarf. And I use this opportunity because it's kind of chilly out here, actually. So, gave me this nice big white Afghani or Kashmiri scarf, whatever. So, I don't know how many times I've wrapped it around myself. Okay. So, he gave me this scarf. He sold me the scarf. It wasn't that, Uncle Masir wasn't feeling that generous. He gifted me, he sold me the scarf on condition that I wear it. Is there a material benefit to Uncle Masir if I wear his scarf or not directly? Material benefit? No. So such conditions are valid insofar as they don't corrupt the contract, but they're not binding. Okay? You sell, you sell your cat Amira, and you say on condition that Ibrahim, you will kiss the cat on its nose 5 times every day. Such conditions are not binding. On condition that you feed it only seafood. You bought the cat, you realize it likes other things too. There's no material benefit, right? When we talk about benefit, we mean material benefit to the seller. Once you sold it, it's not yours. And you don't have a right of, now when it belongs to someone else, it is inviolable for you. You don't have any right over it, nor can you expect or demand anything with respect to it. The car had emotional value, etc. These are un-Islamic concepts. Now there's societal tact, wisdom, discretion, but if let's say this is an heirloom scarf from hand knit in Uncle Masir's village by his great grandfather's personal artisan, whatever, said, I'll sell this to you on condition that you never sell it. There's no material benefit to you whether I sell it or not. So those kinds of conditions are of no consequence. Okay. And then there are conditions that have benefit to one party or the other. And what do we mean by benefit? What do we mean by benefit here?
Material benefit?
Yeah, material benefit. Right? Material benefit is something that you can attach a price to. You can attach a price to. And in general, we keep contracts separate. So conditions not entailed by a contract in which there is benefit, i.e., material benefit to either party, these corrupt the contract. With one exception. What is the exception? There's one exception here, which is unless these conditions are customarily made and do not lead to dispute. Unless these conditions are customarily made and do not lead to dispute. Or we can put it more precisely, unless these conditions are customarily made, do not in themselves oppose the Sharia, and do not lead to dispute. Right? So conditions that have benefit for either party, material benefit for either party, are best to avoid because they would corrupt the contract. Unless three conditions are found. These are customarily made. They are not in themselves against the Sharia and do not normally lead to dispute. So, for example, Uncle Latif purchased this fancy sofa set for $5,000. And in the contract itself, what does he stipulate? I, owner of Latif Unlimited, purchase this sofa with these characteristics on condition that Ibrahim Furnishings will hold on to this sofa for 90 days and then deliver it to my house. So, so this is a condition. So once the sofa is sold, who does it belong to?
The buyer.
The buyer. So for the seller to hold on to the sofa in their warehouse for 90 days, this is a benefit for the seller. Storage. That storage has a material value. Storing something for 3 months, for 90 days, has a material value. Correct? So it's like two contracts in one. A sale contract for the purchase of the sofa set for $5,000 plus a contract of storage, which is either for free or hiring. But then and where would the dispute arise? Ibrahim Furnishings realizes our warehouse is full. Why are we stuck with this $5,000 sofa set that we've already sold? So it can be it these things often lead to dispute. So please take your sofa set. And once the 90 days are over, it's quite possible that Uncle Latif will say, you know what? I'll come in 20 days. I'm traveling. So how do you solve this if you want to transact properly? What would be a very simple way to solve these kinds of problems? Yeah, you have two separate contracts. You make one sale, you have a sales contract, you have another agreement, which either it can either be for free, but if it's for free, if someone just keeps something in safekeeping for you, is it binding for them to keep it for you for 90 days? Called wadi'ah. And we'll be coming to the rulings of it. But, one-sided contracts where it's not a contract of exchange, it's not binding. The person says, okay, I'll keep this in safekeeping for 90 days, but suddenly they have too much inventory. They can ask you 10 days from now, please take it back. But now it's not inserted into the sales contract, right? It's separated. Or Uncle Latif doesn't want that headache. He says, okay, I'll pay you $20 to keep it for 90 days. So you separate it into two contracts and it avoids the dispute. And you can do these as what they call sometimes sequential contract. There's a contract A, and there's right after is a contract B. You agree upon that once contract A comes into effect, then you have a contract B that comes into effect. Sale, separately, you have a contract of safekeeping, right, or storage. Avoids the dispute. But people don't deal in this way, unfortunately. Right? The other way is just to rely on trust between people. لا تنسوا الفضل بينكم. Do not forget virtue amongst yourselves. But that, of course, is a two-way street as well, right? And that's what relationships need: trust and give and take. And that's non-contractual. But جبلت الأنفس الشح. So from that, the need came and became increasingly great in later times to consider conditions that were customarily made. And this came up early on too, as we will see in some examples. But the summary of it is that conditions that are customarily made, that are not intrinsically against the Sharia. Is there any intrinsic problem in the seller keeping the sofa set in safekeeping for 3 months? Is there? No, right? It's not. There's nothing intrinsically against the Sharia about this ruling, about this condition. Right? You could, and one example that it's not intrinsically against the Sharia is that you could have a transaction of, you could have a storage agreement, right, which is a type of hire or lease. You're renting some space to store the item. So it's customarily made, not against the Sharia. And number three, it does not normally lead to dispute in normal circumstances. Of course, rare things that you sell someone a black power bank, and then finicky Uncle Masir comes and says, uh, Uncle Rabbani, this is not actually black. This is extremely dark gray. So we go and see what is it customarily considered in the market, right? And so those kinds of things are ignored. So the Majalla took the position that يصح البيع بشرط متعارف. And they took this general principle, right? That it is valid to sell with a condition that is customarily made, which fulfills those three conditions, right? It is a common condition in the market. It doesn't in itself go against the Sharia. And number three, it does not lead to dispute. Okay, so this is an important preamble to look at this section. قال الإمام إبراهيم الحلبي رحمه الله تعالى: والبيع بشرط يقتضيه العقد صحيح كشرط الملك للمشتري. The sale with a condition that is entailed by the contract is valid, such as the condition that the buyer owns the property, right? Because it didn't need to be specified, or the details of the agreement, right? About when payment will take place, when delivery will take place. Rather, these conditions, as Imam, as Sheikh Zada puts it very nicely, they بل يؤكد موجب العقد. They confirm what is entailed by the contract. Okay, and we've discussed these. وكذا بشرط لا يقتضيه العقد ولا نفع فيه لأحد. And likewise, the transaction is valid with a condition not entailed by the contract, but that no one has a benefit from. No one has a material benefit from. كشرط أن لا يبيع الدابة المبيعة, such as the condition that the buyer not sell the animal that was purchased. Right? So this condition, which there's no material benefit to the seller, right? This condition would not affect the validity of the sale, but it is not binding. It is not binding. You should not willfully make these kinds of agreements because it would lead to ill will. So, Uncle Latif moved to rural Thailand, and this family who were very attached to their elephant. They're forced to sell it, but they said, please don't sell the elephant though, because our whole family is in love with the elephant. Said, no, I won't sell it. And then he purchased it and sold it right away. There's the sale itself, but then there's the aspect of not making a promise that you did not intend to fulfill, etc. But that's outside the contract itself. So one should be aware of those kinds of things, right? Okay. Then there are conditions that are corrupting. ولو بشرط لا يقتضيه العقد وفيه نفع لأحد العاقدين أو لمبيع يستحق فهو فاسد. And if one made the sale with a condition not entailed by the contract, and there is a material benefit to either party or to an item or to the subject of the sale, that has rights and responsibilities, i.e., would be a human being, then the sale would be fasid. كبيع عبد على أن يعتقه المشتري, such as selling a, a slave on condition that the buyer free him. It's not entailed by the contract, right? And here, the benefit is to whom? Is to the slave, because he was أهل الاستحقاق. He has material benefit from it. أو يدبره يكاتبه أو أمة على أن يستولدها. And then there's rulings related. فلو أعتقه المشتري عاد البيع صحيحا فيلزم الثمن. وعندهما لا يعود فتلزم القيمة. There's other corrupting conditions. So he tells us وكشرط أن يستخدمه البائع شهرا أو يسكنها أو لا يسلمه إلى رأس الشهر. Or the condition that the seller use the item for a month, or that he continue to reside till the end of the month, or that they not deliver the item till the end of the month. Right? So here, this is a good example, right? This would happen commonly. Say I'm living in a small house, and this young wealthy man named Ibrahim comes. He really likes the place. Says, well, I wanted to move out from it anyways. So we make the sale. And we made the sale now. And I said, well, I sell it to you on condition that I continue to live in it till December 31st. This is two contracts in one. Right? Because as soon as the sale takes place, what happens? Ibrahim owns the apartment. I don't own any property anywhere. So, but let's say if I did, Allahumma salli ala Sayyidina Muhammad. Now, the basis of ownership is that now you want to use your property, but rest of November, all of December, I'm going to stay there. Can this reasonably lead to dispute? Yes. So this is a condition not entailed by the contract. Is there a material benefit in me staying in the property for 40 days? Yeah, there's material benefit, right? It's something that people would pay for. So the best thing to do is to separate it into two contracts. Sale contract, hire contract, or your rental contract. You separate it. So now we have a clear agreement. We've not sort of appended a problematic thing into the main contract. And each entails different items. However, all such conditions that are customarily made are valid. So one cannot take these rulings from the text and start throwing them at you. Can't do this, can't do that. Why? Because للعرف في الشرع اعتباره لذا عليه الحكم قد يدار. Custom is of consideration in the Sharia, which is why rulings may revolve around it. So, for example, it is quite common that if you buy a place, you take ownership of it from the beginning of the month, for example, because it takes time to clear out. So all conditions that are customarily made, not in of themselves against the Sharia, and which don't normally lead to dispute, would not corrupt the contract. But it's best to keep contracts simple. Of course, there are parties like lawyers and other crooks and criminals, financing companies, other. The more complicated a contract is, the more they benefit from it. أو يقرضه المشتري درهما, or on condition that if I sell you this, you will lend me a specified amount of money. أو يهدي له هدية, أو يهدي له هدية, or to gift them a given gift. أو يقطع البائع الثوب ويخيطه قباء أو قميصا, or for the seller, i.e. of cloth, to, once the sale is made, that you cut the cloth and stitch it into a qaba, like a cloak or a long shirt, qamis, أو يحذو النعل, or you bought leather and that you um, work, you put straps on the sandal. أو يشركه, right? You put shirak, you put straps into the sandal. Why? Because you sold leather. Right? So if you sold leather, you own a piece of leather, or you purchased some cloth. Now you own the cloth. Buyer goes and cuts the cloth. Is there a possibility that he cut it wrong? This happened, so it would lead to dispute. So the best thing for tailors to do would be sell the cloth. Okay, this cloth is now yours. Okay, now we have a tailoring contract for the cloth. Do tailors, however, practically, do tailors really want to tell you how much is the cloth and how much is their service? No. Do they want to break things down in this way? No. Even though they should, right? They should. And if they did, there would be barakah in it. But people do what they do. And the Sharia is not just for so we have ideals, but we have principles as well. We have principles. And sometimes the ideals are not fulfilled, but the principles must be upheld. And that's from the pragmatism of the Sharia. But that pragmatism should not make us be minimalist, because being minimalist is like men showing up to the masjid with, just wearing a towel around their awrah. Are they legally naked? Are they legally naked? No. But Ibrahim, would you be comfortable if you're in the women's section and all the men just had a towel wrapped from above the navel to just below the knee and wearing nothing else? No, who would be comfortable? I'd want to have some space between having my shoulder and my sides next to someone else's, uncovered, right? So the same thing in transactions, right? That there's a minimum, but there's that which is better. And clarity and definition is important. He tells us, however, that وَيَصِحُّ فِي النَّعْلِ اسْتِحْسَانًا. It is valid when it comes to the na'al, um, out of legal preference. And the legal preference is لِلتَّعَامُل بِلَا نَكِير, because this was done customarily, that the shoemaker would sell you the piece of leather for the sandal, right? Or they'd sell you the sandal, and then they would insert the strap into it according to your size. So, but the general principle applies to all scenarios where there is established custom. right? And the role of custom here is important. And Sayyid Abdul Latif will share the item of the Majalla related to عرف العادة محكمة, and we can take the commentary on it from شرح القواعد الفقهية of Sheikh Ahmed الزرقاء بإذن الله تعالى. Okay. And then there's other things that corrupt sales as well. Amongst them is unknown deferral. ولا يجوز بيع أمة إلا حملها. It's not valid to sell an amma, but not her fetus. Because you cannot make an exception of something that you cannot sell on its own. You cannot sell the fetus, you can't make an exception of it. ولا البيع إلى النيروز والمهرجان وصوم النصارى وفطر اليهود إن لم يعلم العاقدان ذلك. It is not valid to sell to Neiroz, which is uh, the festival of the Persians, and Mahrajan, right? One is a spring festival, one's the fall festival, or the fasting of the Christians, or the breaking of the fast of the Jews. If the two transacting parties don't know that, if I, and you have to keep in mind in business, right? People, every day is money. So if I say, Uncle Masir, I sell you this, 100 of these power banks payable on Lent. Do you know when Lent is?
No.
And nor do I, right? So, right, so that would be problematic, right? If both parties don't know that. And in Muslim lands, it would not necessarily be clearly known. But if it's customarily known, like if someone says on payable on Christmas Day, in the US, is Christmas Day very clearly known? Uncle Latif, is Christmas Day very clearly known? When is it?
Yes.
So if someone says, well, I didn't know Christmas was December 25th. I thought it was like a few weeks later. Would that ignorance be customarily accepted?
No.
Right? So المعروف عرفا كالمشروط شرطا, right? Something that is customarily known as if soundly stipulated. So here the assumption is it's not clearly known in society, and the two parties don't know it. ولا البيع إلى الحصاد والدياس, right? Nor sale to the time of harvesting, or the time of sorting through the wheat. والقطاف, or plucking the fruits. والجزاز, right? Or when the sheep are shorn. وقدوم الحاج, or when the Hajj caravan comes back. Because these are non-fixed days, so it would lead to dispute. Right? وتصح الكفالة إلى هذه الأوقات. However, giving a kafala, making a guarantee, right, of payment, for example, to these days is allowed because guarantees are based on trust, and slight non-definition is allowed in kafala. فإن أسقط الأجل قبل حلوله صح. But in these scenarios where the item was deferred to a non-defined or insufficiently defined date, if they rectify it before that time comes, the contract then is valid because it has been rectified. وكذا لو باع مطلقا ثم أجل إلى هذه الأوقات. Likewise, if one sold unconditionally and then one deferred it to these times. it would be valid. Right? It would be valid. Because it's as if you say you could pay me later, right? But so a little bit of non-definition would be allowed in that debt, right? So the scenario would be sold 100 of these power banks to Uncle Masir. And the assumption is payment's due now. I say, okay, you can pay me back after the harvest season is over. Because the harvest season, there's only slight difference. So you can defer a debt with a certain amount of non-definition. And typically, the non-definition in this scenario would be minor. Then, what about selling a share of a house? ومن باع نصيبه من دار يجوز إن علمه المتعاقدان. Right? If, for example, if there are two inheritors, for example, so they both inherited a third of the house. So if one sells their third to the other party, or let's say they have a wealthy relative, and they say, oh, mashallah, 4 children who are huffaz, he gifted them a large farm. So establish a hifz school here. Now, one of them doesn't want to establish a hifz school, doesn't want to be involved in a family initiative like that. He wants to move to Botswana because he got married to a female scholar over there. So he wants to sell his quarter. Now, that quarter ownership is a quarter of the whole. So as long as the share is known, you can sell that share. You can sell that share. Or if each owns a part of it, but it's known by the parties, which part did you own? Right? So the person who sold it said, okay, the oldest one has the house, this one has this part of the property, this one has that part of the property, and one of them wants to sell their share. As long as the party you're selling to knows what part is being sold, either a percentage or which specific part of a property. The dar here would be a property, a residential property. It would apply to other properties. As long as the two parties know what it is, it would be valid to do so. Contrary to Abu Yusuf's concern was lack of definition could lead to dispute. ويكفي علم المشتري عند Muhammad. And according to Muhammad, as long as the buyer knows what they're buying, that is sufficient. Right? So it's possible that the seller doesn't know. Like in our scenario, so Haji Iqbal sold, he gifted his property to Sidi Sulaiman and Sidi Sulaiman's wife and 2 friends. And he defined who owns what. Now, Sidi Sulaiman hasn't seen the house, but he didn't want a property in southern Argentina. He's a northerner, wants to stay in the north. But he doesn't know the house. But the person he's selling it to, his old friend, he knows the house. As long as the buyer knows the house, it's sufficient. So this is the various positions on this. And we'll finish the lesson next time by looking at the derivative rulings of corrupt sales. And with that, we'll finish the section, bi'idhnillahi ta'ala. But I really wanted to touch upon these concepts and this issue of conditions in sales, which we've touched upon a little. We'll give you a few readings on it, but in general, Um, this is an area of a lot of concern amongst contemporary ulama as well. The the large fiqh councils, which we respect, and generally this is what financial institutions and others follow. However, and this idea, they have over embraced the notion of synthetic contracts, what they call in Arabic al-uqud al-murakkaba. And this promotes what's called financial engineering. So basically, you can build any kind of quote unquote financial product to mimic any conventional financial product, quote unquote, but in an Islamic manner. And this very often may be contractually Islamic, but it's not a desirable contract. It's like someone showing up to Friday prayer with, you know, with stuff that they gathered from someone's kitchen. So you're wearing plastic bags and garbage bag and napkins, and so your whole aura is covered. You maybe even have, you know, a whole bunch of napkins on your head for head covering. So, you put stuff on your head, so you're fully dressed. But is that a desirable way of conducting yourself? No. Okay? No. So this is one of the areas where, alhamdulillah, there was a time early in the 20th century, after the shock of the First World War and so on. If you know Arabic, you should read the poem of Imam Muhammad Zahid al-Kawthari of the state of the Ummah after the First World War. It's called and the impending fall of the Ottomans. I mean, they're essentially, the Ottoman Empire had essentially died. It just, the dead body had to be just kicked over. We just took a couple more years. It was a very tough situation. So ulama first proved that an Islamic alternative is viable. Then they showed that it is workable. But then many of the initial alternatives are they ideal? No. But not everything in life is ideal, but we go towards better solutions. It's like in marriage, right? Does everybody always have the ideal relation? No, but we should not lose sight of what is the ideal, and we should not lose sight of what are the principles, but we should direct the principles not to just settle for the minimum, but to strive towards al-ma'ruf, that which is good, striving towards al-ihsan. Right? يعني إذا عمل أحدكم عملا فليحسنه. So we ask Allah subhanahu wa ta'ala for understanding and wisdom, and we'll continue looking at the rulings of corrupt sales. وصلى الله على سيدنا ونبينا وحبيبنا قرة عيننا محمد وعلى آله وصحبه وسلم. وآخر دعوانا أن الحمد لله رب العالمين. Any questions before we close this part? Does the same ruling apply to Eid because we don't know when it would be? No, but that's not considered a major jihad. Like a jihad of one day is not considered a major jihad. It would not be a jahala that would lead to dispute amongst Muslims. Of course, dates that are societally known, right? There's also the issue of validating contracts, right? Like if you're in the United States and you said, okay, to Martin Luther King Day, there's also the aspect that let the two transacting parties be aware. Like if it's a fixed day and you claim ignorance of it, that's your deficiency. So at least in court, a Muslim judge would not accept that you didn't know what day that was. Because you agreed to that date. Like someone says, if two people go to court and they say, well, we agreed that payment was due on Yawm al-Mawlid. But someone says, but technically there's difference of opinion on when the Prophet ﷺ was born. But Yawm al-Mawlid, customarily, when is it considered? 12th Rabi al-Awwal, right? So is there a difference of opinion about that? Yes, there is. But al-ma'ruf urfan kal-mashrut, shartan, right? It's considered sahih. That was customary loans. It's soundly specified. And you specified to that date, so you're negating that which you specified is rejected. There's a qaida fiqhiyya that's very interesting in wording. من سعى في نقض ما تم من جهته فسعيه مردود عليه. Anyone who takes the means to negate something that was completed from their side, their striving is rejected. So someone gets married in a marriage that's valid in the Hanafi school, then says, well, I've decided I'm Shafi'i, so my marriage wasn't valid. No. When you entered into it, you the assumption is you're doing so in a rational, valid manner. So then trying to negate your own action would be rejected. Um, any other questions, Sadati? Does the ruling on non-Muslims buying a mushaf apply to translations too? No. With the mushaf itself, right? The issue would be that we take the step we strive to take the step to ensure that they would treat it respectfully. If one ran a Muslim bookstore, I have a friend who runs a Muslim bookstore. I keep telling him, why don't you carry more mushafs? He said it's too tricky. But the right thing to do is to have a note on proper treatment, right? Like to have a note on proper treatment of the mushaf, that if you no longer need it, where to dispose of it, that you can drop it off at the nearest Islamic center, etc. If you want to do something of ma'ruf as a bookseller, for example, that if you no longer need it, just contact us and we will take it back. So that and the same thing would apply to translations. The translations have of the hurma of the Quran. So that's in terms of doing things better. Is there an excuse? As a seller, let's say you're selling online, you're selling. You're not responsible for who's buying. But if you want to adopt the way of ma'ruf, the way of ihsan, then you would take the means to instill respect and reverence for the book of Allah subhanahu wa ta'ala. There's a very beneficial paradigm that Imam al-Ghazali gives in his book in the Ihya, Kitab Adab al-Kasbi wal-Ma'isha, that he defines there's two levels in which one can transact as a believer. There's al-adl, which is to be just, which is fulfilling rights and responsibilities at the basic level. And then there's ihsan, which is to strive to do things in the most complete way, just to do them in accordance with the sunnah, outwardly and inwardly. There's a third level that is pointed out by the ulama, as Shaykh Hassan al-Hindi, may Allah bless him and protect him, points out, which is al-ma'ruf, which is good ways, which is not at the perfect way, it's not at the level of excellence, but is in ways of good. And that's where the minimum we should operate at is al-adl, which is ada'ul haqq, just fulfilling rights, and to incorporate some ma'ruf, some good into it, while striving for ihsan. وصلى الله على سيدنا ونبينا محمد